Ready? Legal matter, exercise number 18, very important matter for exam purpose, which contains 1000 word. Start. The second part of clause 3, namely, and in particular and without prejudice to the generality of this clause, is illustrative of acquisitions for public purposes. The lands of acquisitions mentioned in clauses A to G as illustrative of lands being acquired or held for public purpose. It is to be noted that the phrase acquired or held also that is not necessary that land which was acquired for a public purpose must continue to be held for that purpose. If it is neither acquired or held for a public purpose, it will come within the clause. So the fact that after being acquired for the public purpose, the land in dispute was let out to the defendant will not take it outside the purview of clause 3 in any event. It was acquired for a public purpose. The trial court found that the acquisition in the present case was covered by clause C of section 8. Municipalities Act section 8C mentions reclaiming unhealthy localities. In this case, the acquisition related to sanction. In our opinion, the purpose of the acquisition is clearly covered by clause C. It thus appears that the land was such in which hereditary rights could not accrue. Now comes the submission which has been pressed by learned counsel for the petitioners that no suit having been filed within the limitation prescribed under the Limitation Act 1963, the rights, if any, of the respondents have extinguished. It is relevant to note that the land which was acquired was an agricultural land and the rights which are claimed by the petitioners are rights claimed under the Tenancy Act. By virtue of section 29, the limitation prescribed under the Special Act shall prevail over the limitation prescribed under the Limitation Act 1963. UP Tenancy Act 1939 itself providing various limitations for suits and proceedings under the UP Tenancy Act. It is not necessary to refer to limitation prescribed under Article 67 and 112 as relied by learned counsel for the petitioners. The scheme of UP Tenancy Act have been framed in a manner that no hereditary rights can accrue on a land which was acquired or held for public purpose and which was covered by section 30 subsection 3. When the Tenancy Act itself contemplates non-extinction of rights of the owner over a land which was acquired and held for public purpose by merely not filing suit under section 180, nothing can be read in the Limitation Act by which the rights of the respondents can be said to be extinguished. The submission which has been also pressed by learned counsel for the petitioner is that suit filed under section 175 of the Tenancy Act having not been held to be maintainable up to the Board of Revenue and proceedings under the UP Public Premises Eviction of Unauthorized Occupants Act initiated by Nagar Mahapalika being pending, the petitioners cannot be dispossessed as noticed above. The writ petition by other persons who were claiming possession on other plots comprised in 45 hectares of land which is said to be transferred to Allahabad Development Authority, having been dismissed by this court taking the view that if so advised they may file suit for declaratory injunction, which decision was affirmed up to the apex court, and secondly in suit filed by similarly situated persons the interim injunction was refused by the appellate court, which has been affirmed up to the apex court. We are not persuaded to entertain this writ petition. The petitioners also deserve the same treatment, that is dismissal of the writ petition. It shall be left open to them to institute a suit for declaration and injunction. Learned Counsel for the Allahabad Development Authority has pointed out that out of the plots on which petitioner's father was given short-term allotment and on which the petitioners claim possession are plots numbers 62/3, 82/3 and 84/3, which are also subject matter of suit number 483 of 2006. Wasimullah and others versus Nagar Nigam and others. It may be that those petitioners, Wasimullah and others, who were also claiming rights similar in nature which are claimed by the petitioners. The petitioners should also be at liberty to institute a suit for declaration and injunction in a competent court. In view of the fact that the interim injunction granted by the trial court in the suit filed by similarly situated persons in the year 2006 in the Court of Civil Judge (Senior Division) out Allahabad, which injunction was set aside by appellate court and maintained by the High Court by the detailed judgment dated 11/3/2008 in writ petition number 47111 of 2006. Nizamuddin versus Nagar Nigam, Annexure 7 to the counter affidavit filed by the respondent number 2, we are not inclined to grant any relief in this writ petition. Stop. Next para. The rights which are claimed by the petitioners in this writ petitions, including their claim that rights of respondents have been extinguished, are the issues for adjudication of which evidence shall be required. When the claim of the respondents is that possession of land was handed over by Nagar Nigam to Allahabad Development Authority on 23/2005, it is appropriate that petitioners may also be given opportunity to institute a suit in a competent court for establishing their rights. Insofar as the judgment which has been relied by learned counsel for the petitioners in the case of Rame Goda (out) is concerned, there cannot be any dispute to the proposition laid down by the apex court in the said case that a person in settled possession is entitled for protection. In the said case, a suit was filed by the plaintiff which was decreed by the trial court, which decree was upheld by the High Court, restraining the defendant appellant. The defendant appellant had come to the apex court against the said judgment. Case in Rame Goda (out) arose from a civil suit in which it was laid down that a person in a settled possession is entitled for protection. As observed above, it shall be open to the petitioners to establish their rights in a civil court, including their rights to maintain possession, the issues determination of which require evidence cannot be undertaken in proceedings under Article 226 of the Constitution of India. Full stop. Thank you very much, guys. Again, I am requesting, please always try to repeat the matter, then only your fluency and accuracy on steno will improve. And also there is one more request. If you found the matter is excellent for exam purpose, you can give your valuable comment on my YouTube channel. And also I'm requesting, please subscribe my channel so that I can upload some more audio like this. Thank you very much, guys.